Are you a loved one facing drug charges, or do you have questions about the process that goes through in defending drug charges in state and federal court? We've created this video as a deep dive into a variety of these issues and encourage you to check the chapters below for specific answers to your questions. In the meantime, please watch this video and let us know what other type of content and information you'd like in the comments. I'm Attorney John Cannon, owner and founder of Cannon Associates in Oklahoma City. And as a former prosecutor and longtime criminal defense attorney, I've seen the impact that drug charges, drug trafficking, and related offenses can have not only on an individual, but their family and community. From my experience defending and prosecuting these cases, it's important to keep in mind there are many aspects to handling and being charged with a drug offense. Every drug offense, whether trafficking, drug conspiracy, or less serious charges, come with their own unique challenges, defenses, and avenues of approach to try and seek the best outcome possible for a client facing these types of drug charges. There's really four common areas of drug charges in state court in Oklahoma. The first being drug trafficking. Drug trafficking can either be aggravated or simple drug trafficking, which is really based on the weight of the substance. There's no evidence necessary to show the intention to sell or distribute these drugs. All that matters in state court is that law enforcement can connect you to a specific weight of drugs. Aggravated drug trafficking is typically limited to when someone has a very large, specific amount of the type of drug in question, where simple trafficking can be a lower amount that's necessary to be charged with one of the most serious drug offenses. The second type of drug offense in Oklahoma State Court, which is actually the most common, is possession with intent to distribute, or PWI. PWI actually has, as the title alludes to, an intention element. Law enforcement or prosecutors must show that there is an intent to actually share, distribute, or sell drugs in order to sustain a conviction on these types of charges. Law enforcement or prosecutors will often use drug ledgers, individual wrapping, scales, or other evidence to show that a person not only consumed drugs, but was actively involved in selling them. In state court, aggravated drug trafficking is the most serious drug offense that someone can face. And really what it means is that law enforcement or prosecution believes that the requisite weight of drugs was in the possession of a party or group involved in moving illegal drugs. Aggravated drug trafficking carries the longest prison sentences. It also mandates that someone serves 85% of their prison sentence before they're released, and it has the longest prison sentences of all drug offenses. Recently, possession of drugs in Oklahoma was a felony offense in all types of common street drugs other than marijuana. However, in recent years, that has been changed, where the vast majority of simple possession charges are misdemeanor offenses. The fourth common drug charge in the state of Oklahoma is possession of drug paraphernalia. Now, this is something that is often charged as an accompanying charge with a possession or possession with intent charged separately, but this just means that law enforcement or prosecutors believe that there is something that is used along with marijuana or another illicit drug, whether it is a pipe, a bong, scales, or something else that's connected to the drug use itself. Drug paraphernalia charges do not require the actual substance to be detected, but that law enforcement can show that it was being used with or for the purposes of consuming an illegal drug. So based on the variety of circumstances that lead to law enforcement or prosecution charging drug offenses, there's a very type of possessions that exist in our state. Under Oklahoma criminal statutes, there's typically two types of drug possession, one of which is actual and the second is constructive. Actual possession is the most common type that you find in criminal cases, where someone is found with the substance on their actual person, be it in their pocket, in their hand, or immediately within the grab area where they're found by law enforcement. The second type of drug possession can lead to a variety of defenses largely based on the lack of evidence connecting a person to the drugs itself. And that second common type is constructive possession. In order for prosecution to sustain a conviction for constructive possession of a legal drug, they must be able to show that you had the ability and intent to control the disposition of the object. Now that's a lot of legalese, which basically means you knew where something was and you had dominion and control over it. So one of the most common circumstances that prosecutors try and prove these cases is someone is in a car and the substance is found somewhere that's not within their grab area or in their actual physical possession. The Oklahoma State Legislature and prosecutors take allegations of drug crimes, especially in near proximity to where children will be, exceedingly seriously. So someone that's charged with possession of, distribution of, trafficking of a specific drug within 2,000 feet of a school, a park, or other location that legislature or prosecutors believe that children would be, has much harsher penalties. The punishment ranges for any of these offenses can be twice that if it is alleged that it took place within that specific distance. So if someone were facing a drug charge that carries 2 years to 10 years in prison, then that person could be facing a punishment range of 4 years to 20 years just based on the element of its proximity to that location to try and reduce the likelihood that people will commit these offenses in proximity to where children will be present. It's important to keep in mind that just because an offense took place within Oklahoma does not mean that that crime will be prosecuted in Oklahoma state courts. When something takes place within a state's boundaries, but also within federal jurisdiction or on federal land, that takes away the state's ability to prosecute and transfers that over to the federal government. So if a service member, a contractor, or a family member, if anyone is caught with drugs or alleged to have committed a drug offense on a federal institution, then they would be prosecuted in federal court for those offenses, which comes with potentially far more serious outcomes than the common resolutions that you find in state court. Another interesting issue is that of criminal offenses that are alleged to have occurred on Indian land in the state of Oklahoma. Since the U.S. Supreme Court's decision in McGirt, the issue of what is and is not state land has become a very contentious and interesting issue in the state of Oklahoma. Typically speaking, anything east of I-35 and north of I-40 has a good chance of being considered Indian land based on that Supreme Court decision. But wherever you may find yourself, if there's a connection to Indian territory and if an involved party is themselves Native American or has lineage that is Native American, there may be a potential to have that charge in federal court as opposed to state court. So it's a really interesting time in the state of Oklahoma because it's not only the underlying alleged drug offense, but also the person and the place that dictates now what potential penalties and what potential court system you would be facing. I'd like to tell you about the different consequences based on the type of offense that someone may face in Oklahoma. As we discussed previously, the most serious type of drug charges in Oklahoma is aggravated drug trafficking, which requires a person possess such a great amount of a specific drug, either actually or constructively, that it's defined as aggravated drug trafficking. In some aggravated drug trafficking, people can be facing up to life in prison as a first-time offender and also the potential for mandatory minimums. Another concern in aggravated drug trafficking cases is that it falls under the 85% rule for Oklahoma, which means there are certain offenses in Oklahoma that a person must serve 85% of their defined sentence before they're eligible to start receiving good time credits or parole. So if someone were to serve 10 years on aggravated drug trafficking, they would have to serve 8.5 calendar years before they would be eligible for release. Only the most serious charges in the state of Oklahoma have the 85% rule attributed to them. Aggravated drug trafficking is the most serious drug offense that someone can face in the state of Oklahoma, and the specific drug and the specific amount dictates how serious that punishment will be. From marijuana being one of the least serious consequences, up to cocaine, heroin, or fentanyl being some of the most serious consequences for aggravated drug trafficking. The next and a more common type of drug offense that I want to talk to you about is trafficking of drugs, which again is based on the allegation of actual or constructive possession of a specific amount of the substance in question. In trafficking offenses, the punishment range is 0 years to 20 years in prison without a prior conviction in most circumstances. However, with a prior record, that punishment can immediately jump up to the potential for life in prison. Now, important thing to keep in mind is that the 85% rule does not apply to simple trafficking charges in Oklahoma. However, if you or a loved one are required to serve a prison sentence on a trafficking charge, if you are not paroled out at the first shot in front of the Oklahoma Parole Board, you are very likely to serve the full 85% of that sentence before being released by the Pardon and Parole Board. So, walking the dog for you on the math, if a person were sentenced to 10 years in state prison on simple trafficking charges, if they were not successful at the first go in front of the parole board in 3.5, 4 years, they would likely have to serve nearly 9 years before being able to get out of state court custody. The next most serious drug offense is distribution of drugs, which basically means law enforcement or the prosecution believe they've caught you or the loved one actually in the act of selling, distributing, or producing drugs for another party. And without ever having been in trouble before, the crime of distribution of CDS in Oklahoma carries up to 10 years in state prison. Second or subsequent offenses of distribution of CDS carry upwards of 20 years without any other offense than one prior felony conviction. It's important to keep in mind that all of these drug offenses, especially felony allegations, carry substantial prison sentences that, if not fought or mitigated, can result in you or your loved one spending a very long time in state custody based on these allegations. The next offense, which is one of the most common, is the allegation of possession with intent to distribute. Now, recently, Oklahoma changed its law and made simple possession a misdemeanor as opposed to a felony offense. Since that change, state court prosecutors have often sought to find ways to charge people that previously would have been charged with simple possession, now with possession with intent to distribute, so that at least initially, those individuals are facing the potential consequence of a felony conviction and the potential consequence of prison time. All this is necessary, again, for the prosecution to believe they can charge someone with a possession with intent to distribute is anything indicating the person was going to share those drugs or sell those drugs. Even one minuscule piece of evidence may be enough for the prosecution to start you or your loved one's case down the possession with intent to distribute route as opposed to simple possession. Now, possession with intent to distribute does not have a mandatory minimum. However, with any prior felony conviction, a completely clean record, a person will be facing up to 7 years in state prison for possession with intent to distribute without any prior criminal record. The last and least serious offense is the newly revised misdemeanor possession of drugs. If you're a person who is charged with possession of any illegal substance, be it marijuana without a prescription card, cocaine, heroin, ecstasy, fentanyl, or any other illegal substance, will be facing a misdemeanor charge for that allegation and could face up to a year in county jail. Now, an important thing to keep in mind is that all of these offenses carry varying fine levels, including aggravated drug trafficking carries the potential of up to a $500,000 fine. So not only are you and the loved one facing the potential consequence of incarceration, be it for up to a year for a misdemeanor or up to 20 years or life for more serious drug charges, there's also the potential for serious fines that go along with these cases. The prosecution has the burden not only to prove that you in fact possess drugs, but what you had was in fact drugs. And the process to do that is by the object or the substance that was captured or seized by law enforcement being submitted to the state lab and tested and proven to a scientific degree that those substances are in fact an illegal drug. Many times when law enforcement submits drugs for testing, it turns out that it's not in fact the drug in question, or does not have trace amounts of the most serious drug and only contains a less serious type of drug in the mixture that is documented by law enforcement. The issue of drug testing is very important in drug defense cases. For one, in drug trafficking offenses, law enforcement and the prosecution must prove the requisite weight of drugs. So if you have a drug trafficking case, an important offense to consider is having those drugs tested, because oftentimes when they're submitted to the lab and the test results come back with the weight, if it is 1 gram or 1 ounce short of the requisite weight for trafficking amount, you can no longer be charged with drug trafficking because the government has insufficient evidence to show that you possess the requisite weight of drugs for drug trafficking charges. Another important thing to keep in mind in drug defense or drug trafficking defense is the government must prove that the drugs in question are the drugs that you were found with. Chain of custody, or the ability to show that the drugs found in someone's home or in someone's vehicle or in some location are the same drugs that are presented to a jury in your trial months, if not potentially a year later. Law enforcement has processes that they sometimes do, and unfortunately for law enforcement sometimes do not follow to properly document that chain of custody. Whether it's the location that the drugs were found, being properly collected, sealed, marked, and transported by someone with the authority to transport them. And then every time those drugs move between law enforcement officer to evidence locker room, to law enforcement officer, to prosecution's office, and back and forth throughout the process, if there's one break in that chain of custody documenting proper procedures are followed, then the government can no longer show beyond a reasonable doubt that it has a proper chain of custody, and you can defend your case based on those are not the drugs found in my case because the government has failed to document a proper chain of custody in its case. There are far more cases filed and prosecuted in state and federal court across the country than can go to jury trial. In state courts across the country, over 95% of cases are resolved by something other than a jury trial. And that number is even higher in federal courts, including drug charges. What that means is that the state, through the prosecution's office, whether it's the U.S. attorney or the district attorney, and defendants, through their criminal defense attorneys, reach resolutions on almost every single case. There's three ways that any drug case can go in the state of Oklahoma. One is a dismissal of all charges, which is the first and foremost goal for our team in your case. Second is through incarceration, which is what we're trying to avoid for every single client that we represent. And third is probation, which is a very common outcome in drug charges. And there's really two ways that probation can go in state court drug charges. You can either receive a deferred sentence or a suspended sentence. And what that means is that your sentencing date may or may not be the date that you resolve your case. When you receive a deferred sentence, it means that your sentencing date is put off for a period of time, whether it's 1 year, 2 years, 5 years, or some other length of time. And there are things that are required of you to complete while you're on probation. And if you're successful in those things, at your sentencing date or with the assistance of an attorney before your sentencing date, your case can be dismissed, your record can be expunged and sealed as if it never took place. Alternatively, the second probation option is a suspended sentence. And what that means is your sentencing date is today, when your case is resolved. But imposition of that sentence, or prison time or jail time of that sentence, is suspended or set off so long as you do what's required of you on probation. And those terms can be varied from inpatient treatment to community service to fines to classes to other things you must do while you're on probation. If you're successful with those things, at the end of your case, you still have a misdemeanor or felony conviction with a suspended sentence. However, you no longer run the risk of being incarcerated on that charge as the sentence has expired. So it's important, if you're unable to have your case dismissed with the help of an experienced drug defense attorney, that you seek a deferred sentence where the sentencing date is set off, and if you're successful while on probation, your case as a whole is dismissed and you can have the entire record expunged and sealed and not accessible to the public. Expungement means a variety of things depending on the jurisdiction that you're in. Some states don't have any expungement process. Some states, when you get an expungement, it means that the records are deleted, destroyed, as if they never occurred. And many states fall into a third category, including Oklahoma, which means that your records are sealed and not accessible to the public. When you obtain an expungement in Oklahoma, the records are no longer visible online, the records are no longer accessible to employers or any civilian authority, and the records cannot be obtained through OSBI for a background check. However, law enforcement can still access those records, and if you apply for a job with the government or apply for security clearance through the military, they and some other entities will be able to identify whether or not those records are still there, even though they've been expunged or sealed in state. If you are eligible for an expungement, the process is basically like filing a lawsuit against the state. You identify and retain an experienced expungement attorney. They'll help you in drafting the petition, filing your case or your lawsuit, and then serving all the necessary parties and obtaining a hearing date for your expungement hearing. In the example of a criminal expungement, on a run-of-the-mill drug charge, you must notify the law enforcement agency involved, the prosecuting office that handled your case initially, and the State Record Division for Criminal Records. In Oklahoma, that would be OSBI or the State Bureau of Investigations. You must serve each of these parties with a copy that is file stamped of your petition for expungement and also the notice of hearing date telling them when they must appear and when they must appear unless they agree to sign the proposed expungement order. Your attorney can draft that proposed order, send it to the parties, and if they're able to obtain the agreement of all the necessary parties, that expungement order can be presented with all the parties' signatures to the judge. If you get the judge's signature on that order, you can file it and then start the process of following through with expunging or sealing the record in state court as well as law enforcement or arrest records. Most of the time, law enforcement never makes contact with people that are suspected of having drugs unless it's part of an ongoing investigation or a traffic stop. It's important to obey traffic laws because 90+% of cases that end up with people being arrested or prosecuted for DUI or drug offenses comes from alleged traffic violations that lead to further investigation that sometimes result in drugs being found or the police thinking there's sufficient information to arrest someone for a DUI. Now, one of the most concerning things to keep in mind is it's not one or the other. When law enforcement comes into contact with a vehicle, whether it's one person or 10 people in the car, everything that they think that there's probable cause evidence, which is a very low bar to arrest someone for, they can book every single person in that vehicle with each separate offense they think there's sufficient evidence for, and then leave it to the prosecution to decide what, if any, charges will fall. When law enforcement decides to arrest a person for 1, 2, 3, 4, 5, so on and so on offenses, each of those results in the bond schedule that the Sheriff's Department uses, increasing your bond based on each count being stacked on top of each other. So whereas your family may be able to easily afford working with a bondsman to get you out of jail for simple possession of drugs or a DUI by itself, if you're suspected by law enforcement of committing 2, 3, 4, 5 separate offenses, your bond may be so high it may be difficult for your family to bond you out of jail while you're working to fight your case with your defense attorney. One common way that law enforcement comes into contact with drugs is at the end of an investigation, whether it's from a confidential informant or a CI, or just spot and stock or law enforcement observing individuals and their conduct, potentially seeing transactions or multiple vehicles coming and going from a house, which leads them to believe that there may be illegal activity or drug trafficking or drug distribution taking place in that residence or that specific location. When law enforcement has this information, whether it's the Drug Enforcement Administration, DEA, the FBI, or local law enforcement, they will compile this information, submit a probable cause affidavit to a judge, and seek to get an arrest warrant or warrant to search that location. When law enforcement gets a warrant, there's many factors that come into play. What time of day they can execute the warrant, whether they have to knock and announce or can breach the entry, what they can and can't search, and what they're allowed to do and not to do in that location. It's important to keep in mind that execution of the search warrant itself does not mean that what they recovered during that search will be admissible in court. It's two separate processes. There's the process for law enforcement obtaining a warrant that they did or did not do correctly, executing the warrant, which they did or did not do correctly, and both of those can impact whether or not the fruits of that search get to come into court. The Fourth Amendment protects you from unreasonable searches and seizures, and those can and do take place regularly at the behest of a search warrant being executed. Now, there are circumstances that people can search a location without a warrant, and that's typically referred to as exigent circumstances. The idea behind the Fourth Amendment and the case law that circles around this issue is that almost all of the time, law enforcement needs a warrant before they search a location. You may ask why? Well, the reason is that law enforcement is vested in the circumstances. Their case is their investigation, and they may not have the ability to remove themselves and make an objective evaluation of whether it's appropriate to violate your rights by searching or seizing something in that setting. So the founders and all the case law that's come about the Fourth Amendment presumed that a third party, a neutral and withdrawn judge, should look at the facts and circumstances and decide from their vantage point, not in the situation, whether it's appropriate to grant a warrant or not. Now, unfortunately, over time, these exigent circumstances that are supposed to be the exception, not the rule, have gotten larger and larger bandwidth for when they can be used. Some of the most common bases for exigent circumstances is the potential destruction of evidence. In the destruction of evidence circumstance, law enforcement is presenting an argument that that evidence would have been destroyed if they took the time to obtain a warrant, whether it's flushing, burning, or some other way destroying those objects. And this is a very common defense or argument that law enforcement makes for not obtaining a warrant in drug cases. Law enforcement is trained to try and obtain evidence from you with your consent. When law enforcement casually says, "Do you mind if I look around in your car?" or "Would I find anything if we looked around in your car?" they're seeking not only admissions to criminal acts, but also permission or consent to search your vehicle without the question of whether or not they have sufficient grounds to search without obtaining a warrant. It's important to be respectful and answer the questions that law enforcement asks, but at any point if they start interrogating you or asking you to search your property, you should state, "I'd be happy to discuss that with you, but first I must speak with my lawyer." Throwing out the word lawyer is one of the smartest things that you can do in these interactions, and you should stick to your guns of refusing a search, refusing entry to your car, refusing entry to your home until you've had an opportunity to speak with your attorney. Some of the most serious drug charges involve larger investigations and conspiracies that typically are the result of state and federal agencies investigating drug manufacturing and drug conspiracy operations. These cases take weeks, if not months, involve surveillance at multiple locations, and often involve law enforcement attempt to interject CIs or confidential informants into the dynamic. What a CI is someone that law enforcement has been able to flip or has dead to right on some other charge and is getting them to cooperate, in this case, in exchange for leniency or eventually dismissal of these serious potential charges in another circumstance. Now, in many instances, these individuals are called snitches, but in a law enforcement report, they're simply called CI. Now, the identity of these individuals is highly protected and can be used in court in a variety of contexts. Unfortunately, one of the most common uses of CIs, if your loved one is facing criminal charges related to drugs, is that a CI engaged in a transaction with someone and then is able to provide law enforcement with a variety of evidence against potentially one, if not many people involved in the dynamic, which leads to subsequent arrest and prosecution. If you are caught by law enforcement under allegations of serious drug charges, sometimes law enforcement will seek to use you as an informant in order to facilitate further investigation. Now, in the state court setting, this typically is you're contacted by law enforcement, you're advised that the prosecution is willing to work with you or the investigator is willing to work with you, and if you cooperate in 1, 2, 3, or specific number of interactions, it will result in you avoiding the negative consequences of your case itself. If you are considering whether or not you wish to participate with law enforcement this way, it's important to keep in mind that being a CI, confidential informant, or a snitch is very dangerous work. Now, law enforcement cannot force you to participate as a confidential informant. This is not an answer to a question that you must obtain on your own. You are certainly entitled to seek out the guidance or advice of an experienced criminal defense attorney before you make the decision about whether you want to cooperate with law enforcement in your case or in another setting. As a former prosecutor and defense attorney, I have the opportunity to prosecute and defend thousands of drug cases. And one of the things that our team has developed is a process to evaluate and fight for every single client. Every single case that we represent someone in, we look at whether or not there's a suppression motion or something that the cops or law enforcement did that violates our client's rights that should result in evidence being excluded from court. If they can't present the drugs in court, the government doesn't have a case. And we've had many clients who have had their charges dismissed based on a violation of their rights by law enforcement. While our team is working to capture that evidence, to build our defense or build suppression issues, our team is also working to help mitigate that client circumstance. Is this a situation where a client was in the wrong time, at the wrong place, or in a place in their life where they made a poor choice, although it was a decision, it was a poor choice based on the dynamics in their life that led them to being at that place in that time? Oftentimes when law enforcement comes into contact with someone, it's limited to a matter of moments. They create a report, they submit it, and the prosecution has that at their table. But the prosecution needs more, and they rely on the defense bar to tell compelling stories and explain a fuller picture of what's going on in our client's life. Because prosecutors are not only tasked with defending the interest of the government, but also witnesses, victims in case, but also the defendant themselves. So when a defense attorney or their team is able to present a compelling story to explain the circumstances of someone coming into the justice system, it directly benefits the client. So we work with clients to identify what's going on in their life that led them to being in that place. I unfortunately can tell you that most of the clients that we work with in serious drug charges and less serious drug charges are either suffering from mental health issues, drug addiction, behavioral health issues, or some type of influence in their life that led them to this decision that many of us will never have to face. And so when our team works with clients and their families, we strive to identify the rest of the story so we can present to that prosecutor what's going on in this client's life that led them to a place where they made the choice, although a poor choice, to begin using drugs, to self-medicate, or to treat a behavioral or mental health issue they're going through with this substance. And I've found in my experience, both previously as a prosecutor, receiving that useful information from defense attorneys, but also for years now as a defense attorney, that when our team works with the client to build that narrative to fight their case, the suppression issue, an avenue to seek dismissal, that can help mitigate the evidence that the government has. And separately, we work with the client and their family to mitigate the circumstance and tell a full story of who that person is and where they are in their life. Those two things work in tandem to help us seek the best possible outcome for our client, whether it's a dismissal of charges because the government can't get to the evidence that they have based on a suppression issue or a violation of our client's rights, or telling the full picture of the client's story to help build that bigger picture so a client can reach a resolution of their case when all those factors are taken into account, as opposed to just their name, their charges, and their case number. We hope this video has been interesting to you and answered your questions about drug defense in the state and federal court system. If you have other questions or comments or more useful content that you'd like to see, we encourage you to drop your comments or questions below. In the meantime, please visit our website for more information and click subscribe for more useful content.